large audience, although we are planning on returning to running some in-person events very soon. We're very fortunate this evening to be joined by such an esteemed speaker in Michael Horton QC of Quorum Chambers. By way of brief introduction, Michael specialises in complex financial remedy cases and interlast disputes between unmarried couples and other family members. He has particular experience of appellate work and work with an international element. Michael also undertakes some court of protection work. I think Michael has very kindly offered to leave some time at the end of the talk for questions, which I'm told that people can ask rather using the chat bar, but I'll leave Michael to confirm that. And on that note, I will hand over to Michael.
Thank you very much, Henry. It's very kind of you to invite me to talk to this London YRes occasion. I am a member of Resolution. I am neither young nor in London, but nevertheless, I'm very glad to be here this evening, able to talk to you about this. I'm talking to you about the new no-fault divorce law, and I'll be running through both the substantive law and what we know about the procedure in advance, what we're about 6 weeks out from implementation on the 6th of April. You may ask, why me? After all, why would you ask a barrister, let alone a QC, anything to do with divorce procedure, given that we have very little to do with divorce law or the actual practice of divorce law. For my sins, I was on the Family Procedure Rules Committee for 6 years. I have served my sentence. I've now rehabilitated into the community. But at the end of December 2020, right at the end of my term, the rules which I'm going to be talking about this evening were sent out for consultation. And I was able to see what was about to happen, although I take no responsibility for any of the decisions made by the Rules Committee in answer to that consultation. So in terms of what I'm running through this evening, there are 4 areas. Now you'll see on this slide, and hopefully in the chat box, a link to a resource where you can download the materials which are supporting my talk today. I'll run through then firstly the main changes made by the 2020 Act. Of course, it would have been nice had they decided, they being the powers that be, to have a brand new spanking piece of legislation in one place, but oh no, it's an Amendment Act, the 2020 Act. And so one of the things that you'll see in the pack of the papers that accompany this talk is the text of the 73 Act as amended, but we'll go through how it will work once it's amended. We'll also look at when it's coming into force and what transitional arrangements there are, as well as then looking at the new procedure. I should say that in the last few days, David Hodgson's written a really interesting post on the family law sort of website, and he's run through some of the issues that he thinks arise in relation to the new procedure, having looked at the rules. I think he's right about some things, and where he's wrong, respectfully, I will indicate where I disagree with him. So that's the topic of the agenda for tonight. In terms of the materials, I said there's a slide, sorry, forgive me, I'll also be putting up at the end of today a PDF of these slides as well that you can see. The papers contain, and their link is on this slide and also in the chat bar, the text, as I said, of the 73 Act as amended. We've then got the 2 main parts of the family procedure rule that are particularly relevant to divorce procedure. So part 6 is about service, and part 7 is the procedural rules for divorce and other matrimonial orders. And as you'll see, if you get to look at those materials, what the 2020 amendment rules did, or 2022 amendment rules did rather, was to completely substitute part 7. So it's really easy to see what new part 7 is like. But part 6, they said, you know, insert this here, delete that there. So what I've done is to effectively amend or take you through the amended version of part 6 so you can actually read it in an intelligible format. I've also included the 2020 consultation document because actually it's just a really useful, fairly non-legalistic, non-heavy introduction to what was anticipated and what the Rules Committee and the government anticipated how it would work. And then finally, there's an extract from the June 21 Rules Committee minutes dealing with how they envisage costs working under the new system. And I'll talk about that towards right at the end of this evening's talk. So in terms of the new law, well, it's no fault divorce. And so effectively, the main change is the abolition of any vestige of matrimonial fault. And that means that as now, the sole ground for divorce is irretrievable breakdown of marriage, but you're no longer proving that by having to allege adultery or quote unquote unreasonable behavior or any other fact. And so therefore there's no adjudication really at all. Not that there's any adjudication now. How do you prove irretrievable breakdown under the new law? Well, you prove it by making a statement to that effect at the outset and then confirming that is the case in after a 6-month wait. And as we'll see, that 6-month wait is in fact a period of 20 weeks and then a further period of 6 weeks as well. Now, other bits of law that are familiar, there is still going to be an absolute bar on applying for divorce within the first year of marriage. And so if someone wants to have any kind of matrimonial relief other than simply a Section 27 failure to maintain, don't ask me about that, then they're going to need to issue an application for judicial separation. And that option, of course, is available at any time after the marriage has taken place. What we do see under the 2020 changes and in the new rules is the final death knell of the old terminology. And so you'll see on this slide that we're no longer talking about divorce petitions, and we'll have to, you know, put an appropriate amount of money in the swear box every time we talk about them. They're now to be divorce applications. We're no longer talking about decree nihil, they're conditional orders, and absolutes being changed to final orders. And indeed, we're going to get rid of as well the decrees of nullity or judicial separation. So as far as that's concerned, there's no change to the law of nullity or JS. The Queen's Proctor is still in business. So if there are 139 people getting divorced from the same PO box in Reading, then he or she is still going to be able to intervene and apply to set aside those decrees. As David Hodgson said in his recent family law article on their website, we still have the charade of reconciliation certificates. And so if there is a representative acting, they'll need to certify that, as my client's first words were, how soon can I be divorced from that bastard? I haven't, in fact, discussed the prospect of reconciliation with the petitioner. Other things that are still the same, Section 10A, which allows the delaying of a secular divorce until religious divorce has been finalised, those matters remain. So still on the substantive law, the WAG would say that this process is in fact a very British talak, because as we'll see, you say I want a divorce in week 1, you say I want a divorce in week 21 or week 20, and then you say you want a divorce finally when you get your final order. The change that the new Act makes is that one or both parties can now apply for a divorce, and the application has to be accompanied by this statement that the applicant or applicants believe that the marriage has broken down irretrievably. The court cannot make a conditional order, the equivalent of what's now a decree nisi, unless the applicants confirm at least 20 weeks later that they want to continue. And then there has to be a wait of at least 6 weeks between the conditional order and the final order, just as now the same delay between decrees nisi and absolute. The court can shorten those periods. And so you've all probably had some experience of cases where someone's about to die and there's been an application to accelerate decree absolute, or someone's desperate to get remarried and no one objects, things like that. Those provisions will still be there. And interestingly, even the 20-week period can be shortened by the court. It's not entirely clear in what circumstances that would be relevant. But it's absolutely clear that the court cannot extend those periods. And we'll see that that's particularly relevant to the issue of service of the petition, the application. Oh, there goes my swear box. Because the timing is that after 20 weeks of after issue, then the applicant is able to apply for a conditional order subject to service and the time for acknowledgement of service having expired. So that's the key sort of idea of the timetable. As I say, the idea, therefore, is that there will be at least 26 weeks between the start of proceedings and the final divorce order. The government has got the ability by statutory instrument to adjust how that 26 weeks is divided between the initial period of 20 and 6, but it can't lengthen the overall 26-week period. And the two questions in particular that David Hodgson's been writing about is what happens if the respondent is not served until week 19, and what if you start off with an initial joint application for divorce, but then one of the parties no longer wishes to proceed? What happens there? Well, we'll come back to both those issues in a moment or two. I'm going to continue, though, talking about the substantive law by going through the text of the text of the Act. So, in Section 5 of the 73 Act now, there is a bar on the making of a divorce in some cases where the respondent can show grave or other financial hardship, and that bar is completely gone. It's said to be now a dead letter, with what, especially now with pension sharing being available, and certainly the cases where it was available were very limited. But that's gone. You've still got this bizarre busybody intervention. So anybody who can show that something fishy is going on can apply to intervene. Last used in the divorce of Mrs. Simpson back in 1936. And then you've got the provision, obviously, usually the applicant will apply for decree nisi, or now conditional order. The applicant, after 6 weeks, can wait, can then apply for final order. And then if the applicant doesn't apply for final order, then the respondent, after 3 months after the conditional order, can themselves apply for the final order, and that is still on notice to the applicant. The interesting thing, I think, is Section 10.2. Now, Section 10.2 at the moment is only available in cases where the divorce is going on either 2 years separation plus consent to a divorce, or 5 years separation. And that allows a respondent to say, don't let me be divorced until the court's had a chance to consider whether the finances, and in particular what's being offered in relation to the finances for me, are good enough. Now, Section 10.2 applies in all cases, and if the respondent makes that application, the court must not make the order for divorce final unless it's satisfied either that the applicant need not make any financial provision for the respondent, or that the financial provision made is reasonable or fair or the best that can be made in the circumstances, or that the applicant rather undertakes to make provision and the court considers that the order should be made without delay. Now, usually the perception is in our 1970s world that it is a husband or the economically stronger party who is going to be seeking the divorce in these circumstances, and the economically weaker party is saying, whoa there, please do not make this divorce order final. And of course, if it's the case that the economically weaker party who has less of the money is the one seeking to go ahead with the divorce, then in fact, a person looking to delay the divorce who's got more money than the applicant will find it hard rather to persuade the court to entertain this, because if the poor wife needs not make any financial provision for the rich husband, then Section 10.2 application is not going to get anywhere. And it may not be ultimately much good to them. But the fact is that the Section 10.2 application, as this slide makes clear, it is a financial remedy procedural application. And we all know how long it takes to get from Form A to first appointment. And so if the very fact of making an application under Section 10.2, that can effectively extend the period of time before someone's divorced. Now, it may be that this isn't something that people want to do, but it's an opportunity for someone to put a fly in the ointment if they don't want to be divorced against their will. So I think there may be a little bit of a rise in Section 10.2 applications. As I say, there'll be a first appointment, and at that time it will be obvious whether or not there's going to be any hold up on those bases. And in particular, if it's the respondent who's got all the money, then it may be difficult for them to delay the divorce in those circumstances. Just bear in mind that, of course, if it's the quote unquote rich husband who is the respondent and who is now applying under Section 9.2 on notice to the applicant for the conditional order to be made final, the case law at the moment says that the court can only withhold a final order unless there's some pretty exceptional circumstances. And I've given you the reference on the slide, a case of Thacker. And so that suggests that, arguably now an applicant for divorce has somewhat less control over the timing of the making of a final order than a respondent who makes Section 10.2 application. And one of the things that David Hodson suggests in his recent article is that maybe there is an argument for revisiting, the cases such as Thacker, which take a very restrictive view on that. And we'll see what happens about that. So that is a very quick run through the substantive law. Of course, we're going to worry about what the definition of adultery is or what behaviour is, because all of that is out of the window. So the second topic we're looking at is when the Act is due to come into force, and it has been announced that it's going to be the 6th of April, which, as I say, is about 6 weeks' time. As you'll see from the chat bar and the link to the papers there, there was a consultation on amendments to the rules way back in December 2020. It was so long ago that we were still a member of the European Union. And those rules eventually came to fruition in January this year, when, after consultation, the Rules Committee made those rules. We are awaiting forms. We are awaiting guidance, including matters such as costs. Resolution today and a couple of weeks ago said that they are due to publish a comprehensive information pack once all the information is ready. There is a draft, quote unquote, stakeholder information pack that HMCTS are going to send to relevant stakeholders, which I'm sure will include resolution and which will inform their comprehensive information pack. One of the things that is relevant to that is the third issue, which is transitional arrangements. Now, strictly speaking, the existing fault-based divorce law and procedure will apply until the day before the 6th of April 2022. But in the resolution emails today and a couple of weeks ago, they have quoted the HMCTS saying that there'll be cut-off dates before the 6th of April. And depending on which document you use, either the notes from the stakeholder meeting or the draft stakeholder information pack, this suggests that this will be the case for both paper and online cases. So there'll be a period of time, apparently, where neither the online system nor Bury St Edmunds will accept cases. And it's suggested that if you are in a hurry or in a jurisdiction race or any other reason to issue a divorce petition, as it still will be before the 6th of April, you will need to go to a court that you can get into and find a counter at and issue an urgent divorce petition at that court. Certainly, the warning is if you send something in the post to Bury before the 6th of April, there's a real danger that it won't be opened by a human being and logged onto the system until after the event. And if that happens, it will be sent back. The slightly more curious thing is this idea that the divorce online system will be taken effectively offline at some time in advance of the 6th of April. And it's difficult to understand why that's the case. We are told that the new online system is more or less ready, and it will just be the equivalent of flicking a switch, after close of business on the 5th of April, whenever they want to do that, to make the new system work. But certainly at the moment, I've seen some draft information that suggests that after the 26th of March, neither the online system nor Bury will take any more cases. So basically what that means is if your client's dithering or not sure, they need to make their mind up so well before the 26th of March to make sure that they do decide to issue, because there may well be this somewhat unusual hiatus between the old and the new systems. So the last topic, and it's the bulk of my talk today, is going to focus on the actual procedure. And the first thing, obviously, therefore, the first part of that journey, as they love to call it, is making the application. And so it will be possible to do it on paper. And if that's the case, then you send it to Bury. There's a big push to do it online, and the online system, as I say, is supposed to be ready pretty much already. And the assumption is that as at now, if you need to issue an urgent application, you will still be able to do so. But we will see how effective that is after the 6th of April. Service, there's some real interesting changes here. So service by the court is now the default, and service by email, it is now not only allowed, it will be the default. And so unless the applicant doesn't provide an email address, or unless the applicant specifically requests service by post on the respondent, service by email is what will happen. And that service will be at, quote unquote, the respondent's usual email address. So that's all quite modern, and it's not that surprising, I suppose, in a situation where your bulk of your cases will be issued online. And of course, it's quite a big change. I mean, you can't issue, you can issue some civil claims in the online small claims court by email, but most claims for money are still issued and served by post. And of course, changing someone's status is quite a big deal. And it might be thought that getting notice of those proceedings by email was somewhat unusual. And so they kind of have this sort of somewhat unusual safety blanket, whereby service by email is to be accompanied by a postal notice. So the idea is that the applicant supplies both an email address, and that is where service will take place, but also supply a postal address for the respondent. And the postal notice that goes out will be, "Dear Mr. Smith, you should be aware that you've been served by email at this email address." Now, receipt of the postal notice is not service. Conversely, the failure to deliver the postal notice does not mean there has been a failure of service. And so I think it's really the justification for this is that it's a safety blanket. It's really easy. And there was a case about it in the press this week. It was on Bailey a few weeks ago, of someone who was divorced for 10 years without knowing about it. And it's going to be really easy for the fraudsters to make up an email address for Mr. Smith and to create that email address themselves, to send a fake email to them saying, "Dear so-and-so, please use this email address for my divorce when you want to send your divorce petition to me," and then use that fake email address as the address for service, as the respondent's usual email address. Now, of course, the respondent would be able to say in those circumstances, "But that wasn't my usual email address. My usual email address is my usual email address." But it'd also, I think, be more difficult for someone to perpetrate that fraud if they have to give a postal address, which is, again, not the usual postal address or place where the respondent is. So I think it's a little bit of a safety net to try and prevent people making fraudulent divorce applications. So how does it work? Well, you give the court the respondent's email address, the court will serve it by email, and the court will make a record of when the email was sent. And that court record is evidence of service. Now, if the email bounces, then just as at the moment where if the court gets a notice of undelivered postal service, it's got to tell the applicant. Likewise, the court must tell the applicant about that. But unless you've got an email bounce, then you've got your evidence of service. And of course, in due course, the applicant will be able to apply for deemed service. And we'll come back to that process in a moment or two. So we've issued the application. We provide the details of how to serve it. The court has served it. And as I say, on the bottom of this slide, if you've done the email route, you don't need to show that the postal notice arrived for there to be good service. Personal service is still an option. You might use that if there were other documents that needed to be personally served within this jurisdiction. The current rules in Part 6 and Part 7, as they relate to divorce applications, do not prohibit the applicant themselves serving a divorce petition personally on the respondent. And you can see on the slide the definition of personal service. In Family Law Act injunction cases, the rules have been changed. And so the applicant for a non-mol cannot personally serve themselves the order they get or the application they're asking for on a respondent to that non-mol application. Now, the most famous instance of personal service of a divorce petition can be seen in this slide. And I've always thought that that envelope looks rather too small to be a divorce petition. Now, what's wrong with this photo, other than the size of the envelope, is that there's a suggestion that personal service by the applicant won't be permitted. You will see when you look at these pages in the materials that it's been done in a really strange way. If they had wanted to say expressly an applicant for a divorce order cannot personally serve the respondent, you think they might have said so, but you can see that it's in one of the references to personal service that it's got to be done by someone and the applicant personally. Now, the rule in non-mul cases is to protect the applicant. The last thing they're going to want to do is personally serve a respondent who potentially has already subjected them to violence or harassment. I think the argument here is that personal service ought to be something which is done by someone notionally independent and therefore can be a proper, decent evidence of personal service. But there we are. It looks like personal service by the applicant themselves for the divorce won't be permitted under new arrangements. And now we come to the really tricky, perplexing, controversial area, and certainly it's one where if you read Dave Hodgson's article, you can see that it's going to cause some problems. The existing law does not provide any rule or time within which someone has to serve a divorce petition. And subject to the case of Tum, which was about, I think, 2 or 3 years ago, it seems at the moment that you can issue a divorce petition and then sit on it for a bit. So the new rule, Rule 6.6a, says once you've issued your new application, then where it's going to be served by the applicant, and of course the applicant can say to the court, no, I don't want you to serve, I'll do it myself, thank you very much. Where the applicant's doing it, it's got to be done within 28 days of issue. It'll be done by the court. We would have thought a whole lot quicker than that. And so on our example on this slide, the application is issued on the 1st of June this year. Then the respondent's got to be served, obviously, by the 29th of June. And on that basis, given that the earliest date for conditional order is the 19th of October, 20 weeks, you would have thought then that the respondent should have at least 16 weeks between being served and the applicant for conditional order being made. I've used the word there, the respondent is meant to get minimum 16-week service, but that's really my take on it. I don't think there is any official intention that there be that minimum of 16 weeks notice. The problem you have is that you have a rule that says you must do something, and then there is no express sanction in the rules for not doing it within time. And this is where it gets interesting or intricate. Remember that the court cannot extend that 20-week period. So in our example, the conditional order can be applied for on the 19th of October. Forgive me, I'm going backwards and forwards. And so assuming the court is super efficient and the online service is super lovely, then conceivably if the order was made on the same day, then the earliest date for final order will be at 26 weeks on the 30th of November. So is it unfair to the respondent to get less than 16 weeks notice? What if he is served in early October and therefore gets potentially only 2 weeks notice of the application for conditional order? Remember, you've got 14 days to file acknowledgement of service, and if acknowledgement of service is not filed in that period of time, then you will be able, after that period of time and 20 weeks from issue, to go ahead and apply for a conditional order. So you've got your rule 6.6a that says you've got to serve within 28 days. And that is very, very, very similar to the CPR rule about service of claim forms, which says you've got to issue, once you've issued your claim form in a non-foreign foreign case, you've got 4 months afterwards to serve it. And then Rule 6.6b allows the applicant to apply for an extension of time to serve. And that corresponds to, but is in fact not in identical terms, to CPR Rule 7.6. And under the CPR, a late service of a claim form is something which a defendant is entitled to challenge. And if a defendant does challenge late service and says, I've not been properly served, you didn't serve me within the time which applies under CPR 7.5, you didn't get an extension, then if they do that, service is set aside, the proceedings effectively come to an end. And the claimant must either reissue or apply retrospectively for an extension of time. Now, if we have in our example now the divorce petition or the divorce application issued on the 1st of June this year, and let's say the applicant tried to arrange for service by email, believed that the respondent's usual address was something, and you get an email bounce, then the applicant tries to find another email address or tries to find a postal address, tries to find personal service, none of that's working. And so within about 3 weeks, the applicant applies for more time to serve. That is an in-time application, because you've got 28 days to either serve or apply to extend time to serve. The application's got to be supported by evidence, so you've got to show what you have done in order to try and serve and why you're applying for an extension, why you haven't been able to serve so far. And that application will inevitably be without notice, because the whole point is you haven't been able to serve. Then you've got, the court has to then go through this checklist in whether or not to grant an extension of time. It's got to consider whether or not it's the court's fault. Either the courts failed to serve because of a lack of process at the court, or because the method chosen by the court failed, not because the wrong email address was used or something like that. Whether the applicant has taken reasonable steps to serve in time, and whether the applicant has acted promptly, i.e. by making the application. And if the application is after the 28 days, so in our example, for instance, on the 30th of June, which is 29 days after issue, then the applicant must, quote, assert a good reason for applying out of time. Now, I've sort of been looking at the cases since I did these slides, the CPR case law, and of course the CPR is a bit more hot on procedural rigor than we are under the family procedure rules. The CPR takes a pretty strict approach, and if you're applying in time to extend time, then you've got the overriding objective to consider. You need to show a valid reason for an extension. But even if you've got no good reason, then in exceptional circumstances, you'll get an extension of time to serve. And you don't need to show you've taken all reasonable steps to attempt service in time, as long as there's some efforts, I suppose, to extend time. The next slide, I don't think is entirely right, and there's a health warning to it. And the reason why it's not right is that the rule is not the same. The civil rule basically says if you're applying late, you do need to show that you've taken all reasonable steps to attempt service. And the family rule is not the same. But the case law does suggest that incompetence or oversight or waiting some other development are not going to be good reasons for not serving in time. Now, in David Hodgson's article, he suggests that people have come up with the following ideas for not serving in time. One is that there's a fear of domestic violence or harassment in the event of service. For me, that doesn't really cut it. If you're saying that service of process is going to lead to harassment, then you need to be applying for a non-malt at the same time. It's not going to be good enough to cut down the respondent's awareness of the divorce process. to stop the other party being able to react to an English petition by issuing overseas. Again, I mean, that's just really unattractive to say, well, I want to steal a march in the jurisdiction race. That's not going to be a good reason to delay service, or to delay the other side bringing a financial claim. Well, I mean, the whole point of initiating the divorce process is so that, you know, you start to think about that, and if necessary, you can issue a Form A and get the court timetable rolling. So I'm not sure that works. And obviously, it can just be a completely annoying and causes maximum distress. And again, that's not going to be much of a reason. So I think the process is designed to say, look, I am doing my best to serve, but the respondent's evading service. I've sent it to this email address. He's not acknowledged service, and I've not been successful in getting my application for deemed service in. And I'll come back to that in a moment, because I think there's a lot of, you know, covering our derrieres and hedging our bets when it comes to that sort of process that will be required. I think that if an application for extension is refused, then effectively the divorce application cannot proceed. And it also means that if you make an application without notice for an extension, you are under a duty of full and frank disclosure. And if you fail in that duty, or the court is satisfied that the order shouldn't have been made, then the extension of time to serve will be set aside. And if that's the case, the divorce application will not proceed, and the applicant will have to start again in those circumstances. Now, it's different in our context. One of the big issues in the civil context is I'm right up against limitation period, and I still didn't manage to serve my claim form in time. If you don't give me an extension, I'm completely screwed because I won't be able to reissue. Well, in a divorce case, you'll always be able to reissue, subject to any jurisdictional arguing. And it will just therefore be, is it right for the applicant to pay another 593 quid in the context where the respondent's supposed to have a decent amount of notice that he's being divorced, and where the applicant hasn't served for a good reason within the 28 days allowed, or in the circumstances, has the respondent had enough notice? And I think that's the real issue that's not been sort of completely thrashed out. The official guidance is that, or the official HMCTS view, according to Philip Waller, who I spoke to today, who's been carrying on working on this, is that late service is fine, it is valid. But I also think that a respondent who challenges late service will be entitled, unless there's an extension of service, to say this is not valid service and you can't rely upon it when you apply for conditional order. So a respondent who doesn't care, who served late and says, yeah, fine, go ahead and divorce me, no problem. A respondent who served late wants to be awkward, can make an application and say this service is defective, dismiss the petition, make it start again. And I think that is where we're at. And I think, therefore, there will have to be some test cases at some point if a respondent's going to be awkward about it. And they're going to be awkward about it, I think, in jurisdiction disputes, where they're looking to crack on with their divorce in wherever it is going to be. So I think, let's say, there's some real issues about that. One of the things, of course, the court cannot do is to say, okay, so you are going to be 4 weeks late in serving. Don't worry, we'll just extend the 20 weeks by 4 weeks. We know that it can't do that. The statute says it can't do that, which is why, if the court thinks that there should be no extension, then you're in a situation where the applicant has to reissue and pay another issue fee. And if that means she gets left behind in a jurisdiction race, well, that's her lookout. So I think that's the real trickiest aspect of the whole process. As I say, the official guidance is that it's up to really a respondent, I think, to challenge late service. But if they do, and there's no good reason for failing to serve in time or failing to apply for an extension, then they're going to be in trouble. So let's assume that we have served in time. What does the rest of the process look like? Then if you've got service, the applicant is supposed to acknowledge service within 14 days of service. As now, subject to the vagaries of the online system. It must be signed, it must include an address for service, and it must indicate whether the respondent intends to dispute the proceedings. As now, of course, that of itself is not enough to make it a defended case. If the respondent wants to dispute the proceedings, they have to file an answer within 21 days. And I observe at this point that heaven help a respondent who tries to file an answer out of time. I've had personal experience in the last few months, a respondent who didn't file an answer in time, made an application to file an answer out of time. As soon as they became aware that the applicant had applied for a decree nisi and were told that there was a date for pronouncement. And the HMCCS online system did nothing to that for about 2 months, and the decree was pronounced, and it was nearly at the stage of a decree absolute when eventually the court got round to responding. So the online system is very good at dealing with the cases that go straight down the track, but try and get off the train or go into something other than the usual procedure, and you're going to find it quite tricky. We'll come on to what you can dispute in a moment or two. If the respondent doesn't file an acknowledgement of service, then the applicant's going to need to apply for deemed service. So if the court has sent out the application by post or email, there'll be a record in the court system of that service. If there's been personal service, then the applicant can file a certificate of personal service. Otherwise, they're going to, if they haven't got that option, they're going to need to apply for service by an alternative means and or apply for an extension of time to serve. And one would think that if there's any problem with service, you haven't got acknowledgement of service, you might want to cover yourself and apply for an extension of time to serve at the same time as applying for deemed service. Because if you put in an application for deemed service and for some reason the court doesn't give it to you, by the time you get it back, you're going to be out of time to apply for an extension of time to serve, and you won't be acting promptly. So you may want to hedge your bets and apply for deemed service and or, if refused, an application for an extension of time to serve and some other means of service. But in the ordinary course of events, if there is acknowledgement of service, then we are on track. Of course, we mentioned a moment ago that a respondent who wishes to challenge late service will have to make some kind of application to do so. And again, who knows how the online system will cope with that. One thing that's not clear is whether a respondent will know what the time for service is. It's all very well saying a respondent will be able to challenge late service, but unless there's something on either the petition or the acknowledgement of service form that says, have you been served within 28 days of issue or within the time allowed by an extension of time order made under rule 6.6, whatever it is, they're not going to know that they've been served late and have got the ability to challenge that service. So we'll have to wait and see as to how that works as well. But in an ordinary case, if there's no issue about service, if there's been an acknowledgement of service, then the applicant is in a position to apply for their conditional order once 20 weeks from issue has elapsed and the time for acknowledging service or filing an answer has expired. And so as long as they've served, usually within, certainly before week 18, then one will have thought that they can apply for their conditional order after 20 weeks. And in that application, as now they've got to confirm the application is correct, confirm any signature on the acknowledgement of service form, and that application has to be verified by a statement of truth. As now, so will it be under the new system, you don't need to serve the application for conditional order. It's effectively simply submitted to the court, and the first that the respondent will know is, as now, when they get notice that the court has certified that the applicant's entitled to their divorce, and there'll be a date fixed for pronouncement of conditional order. So the rule says that the court will certify entitlement to conditional order if that the application has been made at the permitted time, that the court is satisfied the response has been properly served. I put that word in italics there, but I think that unless there's been a challenge to service, then late service is probably going to be proper service for the purpose of this rule. And of course, it won't give it a certificate of entitlement to a conditional order if the case is not disputed. And we'll have a look at what that means in a second. At the moment, at certificate stage, the court is making a certificate of entitlement to costs as well. That's not going to happen under the new regime. At that point, when you apply for a conditional order, the idea is that you will also be able to apply for costs if, for instance, the respondent has been awkward about service or something else, and then the court can make directions on that application for costs at the certificate stage. So I mentioned about what are the cases in which a respondent can dispute or try and defend the divorce. Of course, there's nothing of substance to defend because there's no factual ground or fact that needs to be proved in order for there to be a divorce. So what are the cases where they're no longer called defended, but disputed cases? Well, the rules say they are where an answer is filed disputing either that the marriage was valid in the first place or that it still subsists. So if someone says we were never married, if someone says, oh, we were married, but we got divorced in Ruritania last year, then of course the court can't make a divorce here. If an answer's filed disputing jurisdiction to entertain proceedings, you're not domiciled here, you don't satisfy any of the criteria in the new primary jurisdiction rules, then again, it's a disputed case. If for some reason there's somehow some cross application for a divorce, then the court's going to need to work out who's going to be entitled to divorce and whether there'll be effectively, like there are now, cross decrees. But the way in which it's defined is that unless the answer falls within those two types of disputes you can see on this slide, then it doesn't matter what it says. The case is a standard one. And it almost seems that you don't even have to strike out an answer that doesn't contain these assertions. Unless your answer is filed disputing validity, subsistence of marriage, or disputing jurisdiction, it's not a disputed case. You put in an answer that says the moon is full of blue cheese, doesn't matter. It's not a disputed case. Put an answer in that says the marriage hasn't broken down irretrievably, not a disputed case. And it would appear that the court doesn't even need to say that. It can just look at it and say, this is not an answer that comes within the definition of disputed case. I can certify entitlement to a decree. I have to wait and see whether that is what happens or whether the court of its own motion strikes out funny or curious answers. But it's certainly the intention that any other attempt to delay the process by those kind of defences will not be effective to do that. So, as we say, you issue, you serve, respondent acknowledges. After 20 weeks, you can apply for conditional order. At the moment, you'll get the certificate of entitlement, and then you'll get your pronouncement of decrees. We're still going on with this charade. As Deputy District Judge, I have done it once, and you literally say, in the cases which are referred to on the list in front of me and published outside the court door, I now pronounce decree nisi, and then you turn the tape off. So we have that nice official in open court process. Occasionally someone will turn up to dispute costs. They won't even do that now at decree nisi or conditional order stage because there won't be any costs order made at that stage. There'll just be directions about costs. So once you've got your conditional order as pronounced in that very moving process, then the applicant is entitled to apply for a final order equivalent to absolute after 6 weeks. And again, that's simply by notice filed with the court, doesn't need to be served on the respondent. You need to explain why you are waiting more than 12 months between conditional order and final order. The list of things you have to explain is much shorter than the decree nisi and decree absolute. You don't need to say whether or not there have been any more children or whether there have been any resumption of cohabitation. If the respondent wishes to go ahead with the final order where the applicant has failed to convert their conditional order into a final order, then if he or she applies after 3 months, then application under section 9.2 is on notice as it is now. So a few other little differences. I'm going to deal with these in one go because they all relate to the same things. There's joint applications. As David Hodson in his article says, that might be quite tricky for a solicitor asked to deal with a joint application where one of the parties then wants to retain that solicitor on some of the other issues in the case. Joint applications don't need to be served. There will be a notice of issue sent to joint applicants. It is suggested that joint applicants should acknowledge receipt of the notice of issue, but it doesn't matter if they don't. And the court doesn't need to be satisfied that they have received it, because the only thing the court has to be satisfied is that every respondent who has to be served has been served, and they're not respondents, they're applicants. So there's no need to prove service in a joint application case. The law allows what was initially a joint divorce application to become a sole divorce application if one then backs out. So one joint applicant is entitled to make a sole application for a conditional order. But here, where one of two joint applicants applies on their own for a sole conditional order, that has to be on notice to the usual joint applicant. They have to get given notification of that, and that will therefore allow the other party, for instance, to make an application under section 10.2 to stop the process after the sole conditional order is made. And again, likewise, if a conditional order has been made in favour of both parties, and then one party wants to go ahead and apply for a final order, again, they've got to give notice to the other party, and again, that would allow the section 10.2 application to stop the order being made final unless there's agreement. So unlike most situations where an applicant for divorce doesn't need to give any notice of either the application for conditional order or for final order, in joint cases which become sole cases, they do. And then costs. The intention is that there won't be any order for costs in standard cases. The idea is that effectively, if someone stumps up their 593 quid, then that's the cost that they have to bear. The court will have discretion, but the intention to say is that in standard cases, it will only be exceptional or where the conduct is unreasonable on behalf of the respondent. And the idea is that you won't be able, as at present, to tick a box in the initial application process to say, I want my costs. You'll have to do that by a separate Part 18 application, or potentially by an application that you can make at the time of the conditional order to say, the respondent messed me about in relation to costs, I've been put to expense, and therefore I should get some or all of my costs of the process. And we'll wait and see. I think that's going to be fleshed out in practice directions. The practice directions to support parts 6 and 7 in relation to the divorce process, I think, have been, are ready to go, subject to a final edit. And we are expecting this HMCTS stakeholder package by the end of this month. So we'll know what is said about that. So finally, the impact on financial remedies. And of course, you can apply for a Form A, we can issue your Form A as soon as there is a divorce on system. And of course, that won't change. You won't be getting your equivalent to decree NISO, you won't be getting a conditional order until 20 weeks at the earliest. So if you issue a Form A in week 2 and have a first appointment before week 20 and you settle, you're going to have to do the usual workaround, which is invite the judge to approve the terms and to direct that the order is made once a conditional order has been pronounced. Now, the other aspect of this, and the intention, I think, is to encourage people prior to the 20-week wait for conditional order applications to sort out finances, whether they need the court timetable in court or to use ADR or other methods of resolution to sort that out. The thing I'm interested in on this slide is the fact that at the moment, both in the D8 paper application, but also on the online process, you can tick a box, say that I will want some kind of financial order from the respondent in the divorce petition. And this is classed as an application for the purpose of Section 28(3) of the Matrimonial Causes Act. So although it's an application that does not lead to the court doing anything, doesn't lead to any kind of hearing date, it is sufficient to prevent the remarriage trap from snapping shut. So if you tick the box in your petition, you never issue a Form A, you then get remarried, you're still entitled to make an application for financial remedies, albeit that you won't get any periodical payments. I don't think there's any intention to change that rule or that practice under the new regime. And so I think it's envisaged that the new D8, or whatever it's going to be called, will have the same box. The new online system will have the same box. There was, back a few years ago, a consultation about the ugly word of delinking, and the former president was very keen on this idea, but no one else was, and it was quietly dropped. But we'll have to wait and see on that as well. So I have rattled through that. As I say, there will be these slides available to download, and that's the address there. So in the chat bar, you had the link to the papers, the materials that I mentioned, and that address contains a PDF of these slides, so you can use those. And thank you very much for listening in your 137 of you. I did say I would take some questions, so I'm going to stop the screen share now and have a look and see if we've got any questions. And here we go. Right. If a joint application is made and one party backs out, no, the answer to that, as I've said, is that if one party backs out, then after the 20 weeks, the person who wants to carry on can make an application for conditional order as a sole applicant, but they need to give notice that they're doing so to the other party, and then the conditional order will be made, but at least the other party, the former joint applicant, is aware of that. And as I say, you don't need to acknowledge service in a joint application because they're both applicants and only a respondent needs to acknowledge service. Can a sole application become a joint application? If so, at what point? It's a good question. I think the answer to that is I don't think it can, actually. If you start off sole, you carry on sole. I'm just going to check that I've not got that wrong. Yeah, so looking at the Act, it says Section 1.1, either or both parties may apply. And Section 110 says that the rules may make provision for an application by both parties to become an application by one, or to be treated as application by one. But I don't think you can go the other way around. Another question, if I have an email address for R but not an address, can I apply for deemed service because the email address or So I think I mentioned this point that service by email is going to be the default. And if you know the respondent's usual email address, then that will be good service. If you don't have a postal address, the court won't be able to send out the notice, the postal notice. Now, the postal notice is not the application, it's not service. And it may be that you might have to make an application to omit a postal address, say I haven't got one, and therefore dispense with the requirement to send the postal notice out. Or it may be that the form will just say, if you haven't got one, don't worry about it, we just won't send one. But I think the danger with that is that if the respondent comes out of the woodwork and says, well, I never got it, and you're potentially making that easier for them to assert that they never received it and try to set aside either service or potentially the whole decree. What form will the statement of application take? Give me no examples for, I don't know what that means, but there's going to be the HMCTS stakeholder information pack distributed to Resolution and others by the end of this month. Resolution have said that they will send that to Resolution members. And so the forms that we're going to be using from April in paper cases are likely to be available within the next couple of weeks. And obviously the online system will show you what it lets you do once it's up and running. So, okay. Do you think there'll be interest parties to approve an FRR pre-conditional order? Oh, yes. So the question there is, will there be an increase in applications by parties to approve a financial remedy order pre-conditional order? And if so, will the court add this application, public application of the portal? So I think there probably will be more cases where, I mean, it's tricky, isn't it? How many cases is the money sorted out within 20 weeks of issue of a divorce petition? It just depends on how early in the divorce process they've decided to issue the petition. If they've been separated for some time and haggling for some time about the money, and then they issue, then it's quite possible that you will have a full financial remedy consent order agreed and nailed down before you've got a conditional order. I think probably the answer is that yes, there will be an increase. It may not be that much. I think in those circumstances, the parties either have to wait. It's certainly not a bad idea to say, can you add this type of application to the portal? But I don't think there are any current plans to do so. So I've managed to get through my slides. I managed to answer all those questions. I'll wait and see if there are any more questions, but otherwise, if that's it, I will just say thank you very much for inviting me to speak to you. Thank you. And I wish you all the best in attempts to make sense of this new process. As I say, the slides and the papers are available on those links. Hopefully over the next couple of weeks, we'll find out a bit more information, things like forms and the like. And I suspect there will be a test case at some situation where an awkward respondent is complaining about late service, and we'll wait to see how that pans out. But other than that, thank you very much and good evening. Henry, do you want to say anything else in conclusion?
Just to say thank you very much for that extremely informative and comprehensive talk, and thank you for making the materials available as well. I'm sure people will be reaching for those as we draw closer to the 6th of April and far beyond. So thank you very much for that.
I should say, obviously, once the rules are changed, then the gov.uk or justice.gov.uk website will obviously have the amended rules. But right now, what you've got in the pack is at least helpful. You can see what will be the rules come 6th of April. But yeah, thank you very much for inviting me. So on that basis, obligatory Zoom wave. And cheerio. Thank you very much.
Thanks, everyone.